One of the most common things that I hear from people is, we're not the kind of people who sue. I hear this all the time from clients who meet with me because lawsuits feel really foreign to people. And I think a lot of people feel like that's not my world. I would only sue as a last resort. That's a good thing. If you can stay out of court, that's always a good thing. Unfortunately, sometimes in life you have to. So today I want to briefly give you an overview of kind of every step of the litigation process. Now, everything I'm going to say is specific to Pennsylvania state court. We're not talking about federal courts. I'm also not talking about any other state's courts, so make sure to get advice specific to your state if you're watching this somewhere else. And everything I'm going to say is general in nature. So in other words, the situation may change depending on what you're facing, but hopefully understanding each step of the litigation process will help you if you've been sued or are suing and are going into court for the first time. In Pennsylvania, every lawsuit starts with the filing of a complaint or a writ of summons. These are two types of documents where you can tell somebody, I'm suing you. A complaint tells the person why you're suing them. It usually has numbered paragraphs. Number 1, I'm suing you because you took my cat. Number 2, you didn't bring back my cat. Number 3, I've suffered emotional damages because you took my cat. Number 4, here's how I'm calculating those damages. Wherefore, please give me money. And you file that with the court, and then somebody has time to answer. A writ of summons is more vague. It just says, I'm suing you, and I'm not telling you why. There are mechanisms under Pennsylvania law where you can require the person to say why they're suing you. Those are the two ways that you start a lawsuit in court in Pennsylvania. Once a complaint is filed with the court, the next process is to serve the complaint. Under Pennsylvania law, in state court, a sheriff typically goes out to serve the complaint on the defendant. This process is designed not to scare the defendant, but to make sure that the defendant gets notice of a lawsuit. We don't want a situation where a complaint is filed and the defendant never finds out. In extreme cases, the defendant can also be served by posting or by publication. This usually happens after the sheriff has tried multiple times to serve someone and they're either dodging service, not coming out of their house, refusing to answer the door, running away from the sheriff on the street, things like that. In those cases, the court will sometimes authorize that the publication of the lawsuit is enough for the person to be on notice, but that's fairly rare. Finally, if someone is out of state under certain circumstances, you can mail that to them to let them know that they've been sued. When you've been served with a lawsuit, you typically have two choices under Pennsylvania law. One is to answer the lawsuit and go through and say why the person is wrong. So if somebody says, you stole money from me, you were supposed to give it back on this date, and I'd given it to you as a loan, you never gave it back, and then all of these damages have been caused to me as a result, you can go through and say, well, number 1, you didn't give the money to me as a loan, it was a gift. Number 2, I gave you half of it back, and number 3, I don't think you've been damaged in any way. An answer is where you go through and dispute what the person has said, and that really initiates the lawsuit and allows us to get into court. You also can move to dismiss or file what we call preliminary objections. Sometimes we call them POs for short. And these are where you say this lawsuit can't go forward for some other reason. It's already been settled. We already had a settlement agreement that they're not telling the court about. There's no jurisdiction. This court doesn't have power to hear this claim. I'm not from Pennsylvania. I've never lived in Pennsylvania. I've never been to Pennsylvania. You can't sue me there. This cause of action, even if it were true, even if everything in the complaint is true, you can't sue me for that because that's something I'm allowed to do. There are a lot of reasons we might PO a complaint. So that's a major strategic decision that you need to make with a lawyer once you've been served with a lawsuit. You have 20 days to decide, do I want to answer or do I want to file POs of some sort? Once you've answered a complaint, we begin a process called discovery. Depending on the judge and the court that's overseeing it, in Pennsylvania State Court, discovery can last anywhere between 6 to 9 months in most cases. Sometimes it can last for years, but that's fairly unusual. Discovery consists of several options that you have to get information from the other side, and in which the other side gets information from you. You can send what we call requests for production of documents, interrogatories, or requests for admission. These are also called written discovery. you might ask from the other side, I want to see your tax returns for the last several years. You said that you were injured in this accident and you're unable to work now and it's ruined your life. Well, I want to see how much you were actually working before the accident. Have you always been out of work? Are you just claiming to be out of work? I want to see proof of that. I want to see your pay stubs from the last 6 months. I want to see all the contracts that you've entered into with any company that's like the one you entered into with us. I want to know about every other litigation you've been involved in. I want to know if you've ever been charged or convicted of a crime. I want to know all sorts of information about the other side, and they're going to want to know it about you. A lot of people are surprised when they're sued or when they're suing to find out how much information you have to give to people in a lawsuit, and you have to give it under oath. People will ask you about your divorce, about your kids, about your last marriage, and you have to answer. So discovery is a really invasive process, but it's also really important because it's designed for us to get all of the information that could possibly be relevant and help to narrow it down for trial. Discovery also includes subpoenas, which is where we ask another person for information who's not part of the lawsuit. I subpoena records from your bank, from your Gmail account, from the company that has data for your phone, from your buddy who lives down the street that I think might have information. And finally, we do something called depositions. Depositions are where we make you show up and answer questions under oath in a conference room. Usually the judge is not present, but at least once during the lawsuit, most of the major witnesses and parties to the suit will have to show up, swear in, and tell everything they know to an attorney, sometimes for as long as 8 hours. A full day is not unusual for those types of events. When discovery is concluded in a lawsuit, the next step is both parties have the opportunity to move for summary judgment. And this is where they tell the court, I don't think we need a trial. We don't need to bring in 12 people from the community. We don't have to waste their time and make them take off of work to decide this issue because it's so clear. It's obvious that I'm going to win. Spoiler alert, it's almost never obvious that you're going to win. So summary judgment is often applied for. It's rarely granted by the court because a judge has to agree that there is no genuine dispute as to any material fact. In other words, there can't be any real dispute about a fact that actually matters to the case. So, if one witness says the light was green and 40 witnesses said the light was red, that is a genuine dispute as to material fact. It doesn't matter that the judge says, I think the 40 people are probably right. If one person truly testified, no, I saw the light and it was green, well, then we have a lawsuit. We have to have a trial. We have to have a jury make that decision. Sometimes, though, you do get summary judgment. It's become clear through the proceedings what's really going on, and all we're arguing over is the law. Everybody agrees that the product was never delivered. Everyone agrees that the money did change hands. The only thing we're disputing is whether legally the defendant had a good reason for not delivering the product under the circumstances and based on the contract. That might be a legal issue that a judge can decide without a trial. Summary judgment is nice if we can get it because, of course, it saves everybody a lot of time and money. And that's the last way to avoid a trial. If a judge has not granted summary judgment to either side, then the judge will typically set a case for trial. This is where either the judge will hear the case and decide it, or a jury of 12 people will come in to decide the case. Parties usually have a right to a jury trial in a case. There are limited exceptions. Sometimes, though, both sides will agree just to let the judge hear the case. It's typically cheaper, it's a little faster. Sometimes the judge will be able to understand issues that a jury might not be able to understand. So if it's a complicated case about contracts or corporate formation or something like that, parties often prefer to have a judge hear the case. Once that trial is heard, then the verdict is entered and the case becomes final. Parties can appeal the case, but in most cases, appeals are limited to trying to prove that something in the trial was done incorrectly, not just, the other side shouldn't have won, they were wrong. You really have to show there's something that was admitted to evidence or something that was done that's not right. For this reason, appeals are very rare, and about 10% of appeals are successful. So it's really important to do well in the litigation process and to win at trial if possible, because an appeal is always sort of an uphill battle from there. So that's a quick overview of how the litigation process works in the Pennsylvania Court of Common Pleas. If you've been sued or if you're suing someone, it's really important that you talk to a lawyer. Maybe it's evident from everything we've just discussed, but lawsuits are incredibly complicated and deadlines can come really fast. If you miss deadlines, judges can be really unforgiving. They don't typically forgive you because you didn't have a lawyer. They don't typically give you more time because your life got busy. They feel like your lawsuit should be the most important thing in your life, whether you're suing or defending. If you're in a lawsuit, call an attorney at Cornerstone Law Firm today for a consultation about your case.